How does a disability insurance company prove that there's other work that you can do that pays sufficient wages so that they don't have to pay you your any occupation disability benefits? Now, many disability insurance policies provide for the payment of disability benefits for 2 years if you're unable to engage in your own occupation. That's called own occupation benefits. But normally the definition of disability will change to what's called any occupation benefits. You'll have to get your policy to read what the terms are in your policy, but generally you have to prove that you're unable to engage in the material and substantial duties of any occupation that you might hypothetically, mythically be qualified for based on your education, your training, the skills that you've learned in other work that would transfer, and your restrictions and limitations. Look, the carrier does not want to pay your any occupation benefits. They're looking for a way to deny your benefits or to terminate the payment of those benefits. But what does the carrier have to do? Well, they have to demonstrate that there is other work that you can perform and that that work will pay a wage such that there are no disability benefits that are due and owing to you. I'm often asked, well, how does the disability carrier prove that there is other work available? The disability carrier has an in-house vocational rehabilitation counselor whose job it is to review your educational background, your work history, and determine whether or not there are skills that you have learned in these other occupations that would transfer to other work. They'll also consider your current physical capabilities, your restrictions and limitations. Now, the disability carrier's vocational evaluator will perform a transferable skills analysis. They use a computer program to do it. Once they've identified other occupations, they next will do what's called a labor market survey. They're trying to determine the wages that these positions they've identified will pay. How does it play out in real life? Let me tell you the story of Mr. Addington, who worked as an underground section foreman at Consul Energy. Now, he stopped working because of chronic neck conditions, back conditions, and knee conditions. He even underwent a knee replacement surgery. After his surgery, his doctors returned him to work with no restrictions and limitations. Liberty's vocational consultant reviewed the medical records that had been reviewed by Liberty's doctors, and based on the restrictions and limitations assigned by Liberty's doctors and the claimant's doctors, which were none, determined that he had could do other work because he had transferable skills. They said he could be a maintenance dispatcher, a production scheduler, and a work order clerk. So what did Liberty do? Well, of course, Liberty denied his claim, and Addington appealed. Liberty had the medical records reviewed, and the Liberty doctor again agreed that he could work full-time, but did assign some restrictions on lifting, sitting, walking, and overhead activity. Now, the vocational evaluator took those restrictions and limitations, put them in a computer, and identified jobs. In fact, they said you can still do a maintenance dispatcher job, the production scheduler, or the work order clerk. Sort of a garbage in, garbage out analysis. But ultimately, of course, he appealed, and he argued that the wages identified did not pay a wage that was sufficient to reduce their exposure. Well, what did the judge do? In the case of Addington versus Senior Vice President Human Resources Consul Energy, which is a Third Circuit case, the court noted that Addington's own doctor felt he could work. Well, that's a recipe for disaster, and that never helps. Addington argued that it was inequitable for Liberty to avoid paying its benefits to him by identifying occupations that earn less than his benefit level. But the judge had to look at the plan, and the plan did not tie his eligibility for benefits to the pay he might receive from another occupation. So the devil in this case was in the details of the plan. And in this case, all Liberty had to do was to identify full-time employment in positions that Addington was trained or qualified to perform. And as a result, the judge ruled against Addington. It was the plan terms that made all the difference, in addition to the fact that his doctor did not support his claim. So what should you do if your claim for benefits has been denied? It's time for you to contact me. I'm a nationwide disability attorney, and I can help you get the disability benefits you deserve regardless of where you live in the United States. If your claim has been denied on the basis that you can do other work, we'll only have 180 days in which to file an appeal of an ERISA denied or terminated claim.